Let me begin by introducing the panelists. We have Paul Michael Keichel. He's a partner at, he's a partner at Schindler's Attorneys. He's in the business rescue team. He was involved in the first Supreme Court of Appeal business rescue case that set a precedent on business rescue. That's about 10 years ago. Then we have Derek from the IQ Business Group. We have Adam Kraker from the IQ Business Group. He's the CEO. We have Chris Sinclair from Agility. We have Ian Fleming from Engaged. We have Dean from Schindler's. And we have Peter Gordon from Engaged Business Turnaround. So the idea today is to briefly run through the provisions relating to business rescue. We'll highlight the important provisions that come into play now and how these provisions are vital, in fact, in this environment. I've been saying on the show that were it not for business rescue provisions, I have no doubt the government would have intervened and promulgated law or regulations limiting, well, allowing for a reprieve or moratorium as the Act allows. So I'm going to start off by sharing the screen. There it goes. Let's make sure I can see it. There we go. I do want to mention that yesterday we did have certain technical difficulties. So if they present again, I'll just ask my panelists to take over. I will rejoin. Okay, so you should have the Companies Act on the screen. It's the Companies Act 1 of 2008, and the relevant provisions in relation to business rescue are found in Section 128. Section 128 begins with the definitions. The definitions are important. We have the definition of affected party. This is relevant insofar as legal standing is concerned. A shareholder, a registered trade union representing employees, or employees are affected persons, and note here a creditor. Business rescue is the temporary supervision of the company. That would be by a business rescue practitioner who's been licensed and appointed by CIPC. And you have, and this is really, really important in today's context, we have the temporary moratorium on the rights of claimants and the company in respect of property in its possession. This is critical because the moratorium affords you that protection. So if the debtor-creditor relationship erodes to a point where the creditor decides to institute legal proceedings, the moratorium, where you could put the company into business rescue and the moratorium kicks in. But interestingly, it was pointed out, in fact, by Paul Michael Keichel yesterday, that the courts have closed down. So we have a situation where only urgent matters can be heard and no other matters. So there has been a moratorium in effect as a result of the shutdown. Also, the time periods that are applicable to court proceedings have been suspended by a regulation that came out last night. So there are really two aspects that have come into effect, and that is just the consequences, the natural consequences of the shutdown, and the fact that we do have this. However, you need to place the company into business rescue for this to kick in. And then, importantly, the development and implementation of a business rescue plan. This is where the shareholders, the directors, and the creditors work together with the business rescue practitioner to put a plan in, because that's the object. Put a plan in and get the creditors to vote on the plan. A court, the High Court has jurisdiction in relation to business rescue, converting a business rescue into a liquidation by way of example, or if there's any oppressive conduct by the business rescue practitioner or nefarious conduct by the business rescue practitioner, you can approach a court and get the necessary relief to have the practitioner removed. And you have independent creditor. This will come in. We'll demonstrate later that both independent and not independent creditors have a vote when it comes to the approval of the business rescue plan. They have a vote, however, the votes are treated differently for the purposes of the approval, but we'll get there. Rescuing the company, that's pretty obvious, and supervision we've dealt with. So how does one place a company into business rescue? This is very, very important. This is something that COBRA does for you on a pro bono basis. Prior to the company going into rescue or COBRA proposing that it goes into rescue, the idea is that companies come into the COBRA ecosystem, and our skilled mediators will try and deal with debtors and creditors to avoid a mountain of claims. If we can maintain the trust between debtors and creditors, we believe that it'll be easy to strike arrangements that suit, to the extent possible, each other's cash flow constraints and requirements. If that doesn't work and the creditor becomes reasonable, then the business rescue practitioner is going to say, well, let's put it into business rescue. How does one do that? A simple majority at a board level. So you propose a resolution and you put it into business rescue. Before I get there, I overlooked this very, very important definition, and that's of financial distress, because the threshold is really, really low. Financial distress is nothing more than it's appearing to be reasonably likely that the company will be, unlikely that the company will be able to pay all of its debts as they become due and payable within the immediately ensuing 6 months. Now, we've been debating this, and I'm firmly of the view that most companies are financially distressed. And I say that because the future is so opaque. No one knows how long the shutdown is going to last for. So the only industries that are potentially not in distress are industries that sell face masks, as an example, where opportunities present themselves. But other than that, as far as I'm concerned, every business is in financial distress, and we'll get there. What's required is that the board put business rescue to the vote. They're actually obliged to in terms of the Companies Act. Let's get back to 129. That's the resolution. What you can also do is you can put the company into business rescue by way of a court application, and that's done when the board cannot resolve, or a creditor or employee or trade union come along and they say it's appropriate. And the board's failing to do it, so we have what's known as locus standi, legal standing. We'll approach a court to place it into business rescue. You see over here, you'll see sub 129 sub 7 reads, if the board of a company has reasonable grounds to believe that the company is financially distressed, but the board has not adopted a resolution contemplated in this section, the board must deliver a written notice to each affected person, setting out criteria referred to in section 1281F that are applicable to the company, and its reasons for not adopting a resolution contemplated in this section. So this is where the obligation arises to notify affected parties as to why you didn't put it into business rescue. This is where COBRA comes in, because the reason that you can give in not putting the company into business rescue, mindful of the fact that directors have an obligation to put it to a vote, the reason you can give is we're trying out the COBRA environment. Okay, it's not in the company's interests to put it into business rescue because there may be costs associated with that. There's the stigma, though the stigma is not as great as it used to be. So we are going to resolve not to, as directors, put it into business rescue, but with one caveat, it has to go into the COBRA system. So your resolution can be, as an alternative, the COBRA ecosystem where we can negotiate on your behalf. Objections to the company resolution, you can object if it's in bad faith. Very often people merely put companies into business rescue to have the moratorium kick in to avoid claims or good claims. So in those circumstances, you can approach a court to convert the business rescue into a liquidation. Or you can set aside the resolution. this is the provisions I was in fact talking to, the court order to begin the business rescue proceedings. Then duration of business rescue proceedings, well, if it's converted into a liquidation because the business rescue has failed, then business rescue enters, and it enters into the liquidation phase. And the liquidation is still, interestingly enough, dealt with in terms of our old Companies Act, the 1973 Companies Act, which has pretty good provisions, investigative provisions that are useful to liquidators. But the application to convert a business rescue into a liquidation generally costs between 30 and 50,000 rands. And importantly, that's another service that COBRA offers pro bono. We're mindful of the fact that if your business goes down, the shareholders are destitute. And the idea is to help those shareholders out and have them not pay under this environment. So just bear that in mind, that if it comes to it, the service is being offered, we will make sure that you do not pay for that conversion. Then, so that's the duration. We then have the general moratorium against unlegal proceedings against the company. Now, this is also important. If you choose to go the business rescue route and you choose to do so outside of the COBRA environment because you know the business rescue practitioner, be armed with a list of all the details of the counterparties to contracts. So as an example, a landlord, have the details, look at the lease agreement, have a look at the domicilium provisions, and be ready with that. Because the moment that a business rescue practitioner is appointed, the business rescue practitioner, and there's another section which we'll go to, but the business rescue practitioner has to send a notice suspending the contracts. Without that notice, the contracts endure, and the rights in terms of the contracts of, let's say, the lessor endure. So if the lessor cancels the lease agreement prior to that notice going out, an eviction under the current state of the law is appropriate. Judge Barachowitz held as much, an eviction despite the moratorium where the lease is being cancelled by the business by a landlord prior to receipt of the notice, there's an eviction. So make a note of that. Naturally, the attorneys within the COBRA environment are very, very alive to this, and will be armed with those notices. Protection of property interests. This is the provision that I'm referring to. You are protected from eviction. You're protected from any vindicatory relief, and claims to property, even movable property, is dealt with in the section. But bear in mind, if there's a cancellation, you won't get that relief. And incidentally, I'll mention that the case that I mentioned, Paul Michael Keichel being involved in, is the Oakdean decision. And that related to the Kyalami racetrack. It relates to the eviction of the Kyalami racetrack and claims in relation to the Kyalami racetrack. And it went to court as to whether a business rescue is appropriate or whether a liquidation was appropriate. Be mindful of the fact that Kyalami was a property owning company and had that property, and that was it, the Kyalami property. Now, the argument was raised in the Supreme Court of Appeal that if you achieve a better return for creditors as a result of a business rescue practitioner coming on board, business rescue is appropriate. And the argument was that the property would not be sold on a forced sale basis if business rescue practitioners got involved, whereas if liquidators got involved, chances are they would sell it by way of an auction. The court held that in those circumstances there wouldn't be a better return for creditors, and having run the liquidation, seen it through, the liquidators' fees in those circumstances in relation to the sale of one property, granted, there was a lot of litigation in relation to it, but they were in the region of about 10 million rands. So it's debatable as to whether a business rescue practitioner would have charged that much. But as I said, in fairness to the liquidators involved in that matter, there was a hell of a lot of litigation involved. They had to attend the Supreme Court of Appeal and stuff, so it may in fact have been on a par with what a business rescue practitioner would have charged. Post-commencement finance, also very, very important. Following yesterday's webinar, incidentally, we have daily webinars, the small groups. Following yesterday's webinar, I had a consultation with a director, CEO of a company, and he was about to put money into the company to pay the staff, which I'm very, very, very happy with, and obviously I'd encourage that. But the advice there is that a consideration prior to putting the money in is whether to put it in as post-commencement finance. And the reason I say that is post-commencement finance gives you preference. So the lender has super preference, as it's known. The lender ranks right up there, even above the South African Revenue Services. So putting money in, at the moment, a lot of shareholders are doing it. A lot of businesses are doing it to assist the staff. Just be mindful of the fact that you can take advantage of the super preference if you go into business rescue, but there's also the stigma of business rescue. But as I said, I don't think the stigma exists. If every business in the country falls within the definition of financially distressed, other than the face mask suppliers, I suggest that the stigma is gone. So very important post-commencement finance. Then we have effects on business rescue on employees and contracts. Here, this is quite a topical issue. We get a lot of questions around employees and business rescue. So the starting point is that business rescue does not change the rights that the employees have in terms of statute. Those rights remain in place, and sections such as 189 of the Labour Relations Act, when it comes to retrenchment, still applies. Now, for those of you who've been involved in a retrenchment process, you know that the retrenchment process involves giving written notice of the reasons and a whole host of requirements in terms of section 189(1), and then, importantly, a joint consensus-seeking consultative process with the employees. And our courts have found that if the consultative process is very, very short, then our courts have held that it's not meaningful. How can you have a meaningful consultation in an abridged period of time? However, a view has been adopted by Labour advocates and attorneys that in the present circumstances, that period can be curtailed, and chances are the Labour court will recognize that this is a unique set of circumstances where it can be curtailed, because what is there to consult on? It's limited. It will consult on the ways to mitigate the adverse effects on the employees. So something to be mindful of. The procedure then, prior to business rescue or post-business rescue, is that you still need to consult with your employees. And first prize, you need to reach an agreement with them on salary. A lot of companies have been just unilaterally imposing 25% haircuts on salaries. That's not appropriate. You must at least have a discussion, try and agree with the employees. And here presents another problem. In terms of our law, if the employees do not agree, to unilateral variation of the employment terms, i.e. a reduction in salary, well, then they can go for a retrenchment and be paid severance pay in accordance with our law. And that's 1 week for every completed year, which is could bankrupt a company. So now you have this issue where what does one do? Does one raise the liability that is due and payable immediately insofar as the severance pay is concerned, or does one sit? There's a problem there that needs to be managed, and employees need to understand that rather have a company post the crisis than take the company to court now, take it for everything that it has, because whilst there'd be a short-term gain now, the company won't exist, and many, many jobs obviously would be affected. So here you go, employment contracts are the same. I just saw something come in. I think there may have been a question, if I can find it. I'm struggling to find the panel. It'll pop up, hopefully. There we go. Let's have a look. Okay, that's an internal chat, so no questions. Please, guys, if you have questions, what makes this super interesting is we actually deal with specific examples of what you're grappling with. So every audience member today has a specific issue. You can ask the panelists. We have, I see Advocate Don Mohan has joined. Now, he was involved in the Oak Dean case. He's a business rescue expert, one of the few in the country. And you now have the likes of a Don Mohan and the opportunity to ask the likes of the Don Mohan and this team any questions. Naturally, and also bear this in mind, you don't need to ask the questions now. This is an open forum. We can set up private Zoom meetings with you and your team.
Maurice, while we're going,
shareholders and directors. Importantly, here again, directors do not somehow relinquish the duties that they owe to the company. In terms of sections 75, 76, and 77 of the Companies Act, directors have duties when it comes to personal financial interests and the general fiduciary duties to act in the interest of the companies. Those remain in place. What does change, however, is the board becomes subordinate to the business rescue practitioner. So the board needs to act in accordance with the reasonable instructions given by the business rescue practitioner and assist in the investigation and the handing over of books. So we'll go through this. You'll see here. So it must continue to exercise the functions of a director. Management function as a duty. Remains duty-bound by the requirements of Section 75 concerning personal financial interests. If there's going to be a contract being entered into, a lease agreement, and the director has an interest in that lease, it has to be disclosed, and the requirements of Section 75 have to be complied with. This is where all the duties are reinforced. So effectively, the directors become statutory servants of the business rescue practitioner. As opposed to an employment agreement kicking in, setting out the duties, they're all set out here and they report to someone, whereas before they only were accountable to the shareholders. Let's see if I've missed anything here. I must attend to the requests of the practitioner at all times. Any action is void unless approved by the practitioner. Qualification of practitioners. What's nice with our practitioners is they are required to be knowledgeable in legal, accounting, or business management profession. That's over here. So they've got to be a member of good standing. There are quite a few business rescue practitioners or wannabe business rescue practitioners trying to apply, and they are trying to get this certificates of good standing. Unfortunately now, as most regulatory offices have closed down, which means that if a business rescue cannot go through, or if a creditor contends that a business rescue, the moratorium has not kicked in, one still has urgent relief, one still can go to the urgent court for relief. Last night's regulation limited the courts to hearing essential matters, urgent matters, and you still have the possibility of having non-urgent matters heard, but it would have to be via a Zoom conference and the judge would have to approve. Removal and replacement of practitioner, I mentioned that earlier. Practitioner also has duties, and the duties are very, very similar to those of directors. If there's a conflict or lack of independence, or no longer satisfies the requirements of Section 138, the practitioner can be removed and replaced by somebody else. General powers and duties of the practitioner: management control, delegation, and to develop the business rescue plan. What I'm going to be doing shortly is handing over to the engaged guys just to take you through what happens on the ground, and I've just got a note from Paul Michael Keichel that he read the directives to say that anything non-urgent will not be heard. Well, I did read video conferencing and the like and may only be related to urgent matters, but we'll see. The practitioner must inform SARS and other regulatory authorities. Importantly, when the business rescue practitioner comes in, it's important for the directors to get on with the business rescue practitioner and for creditors to get on with the business rescue practitioner, because they've got to work together to devise a plan. If they're unable to, and there's a disintegration and trust relationship and no one votes in favor of the plan, then you either go to court on the basis that certain votes have been inappropriate, which you can do. Alternatively, you can go to court and have it converted to a liquidation. We'll see that the practitioner is an officer of the court. Now, attorneys are officers of the court, as are liquidators. So you're accountable to the court and you owe duties to the court. And if you fail in those duties, you can get into a hell of a lot of trouble. And there's a limitation of liability that if the practitioner conducts him or herself negligently, but grossly negligently, then the practitioner can be liable. These are the powers: investigation of affairs of the company. The practitioner is required to investigate the affairs and to have meetings in very, very short time frames. I'll leave it up to the engaged guys to take you through the procedure there. There's, in our law, if there's certain transactions to dispense or dissipate assets with a view to the liquidators of the business rescue practitioners not getting their hands on them, well, those can be set aside. I mean, when creditors do that, all they're doing is inviting massive legal fees and cost orders against them. Directors of the company to cooperate with and assist the practitioner. That's we've dealt with. This is duties to disclose. So there's a duty, obviously, to disclose to the practitioner if there are any proceedings, and that's really just so that the practitioner can get a certain degree of institutional knowledge in order to put the business plan together. And here you go. No person is entitled as against the practitioner to retain possession of any books. Remuneration of the practitioner. The normal remuneration is set by tariff or by agreement with the practitioner. Within COBRA, the practitioner does not charge if the fees, the fees being charged come between a successful liquidation a successful business rescue or liquidation. So essentially that's the means test. If there's, in pro bono matters, one always has a means test. Pro bono kicks in for those that require the assistance. And when it comes to business rescue, it's automatic in the sense that if the business rescue is successful, would be successful, but for professional fees, well, those professional fees will be attended to pro bono. When it comes to the certain other services that are provided by COBRA that are always pro bono, such as the call center, the meeting rooms, and importantly, the conversion from a business rescue to a liquidation. Then, so that's the remuneration of the practitioner. We dealt with that. Rights of employees, I've dealt with that. Participation by creditors. Now, again, an important provision, creditors have a vote and they need to vote in favor of the business rescue plan. So creditors and security holders are entitled to notice of any decisions or meetings or other relevant events concerning the business rescue proceedings of the company. Now, interestingly, I was personally an interested party in a business rescue, and there were certain steps taken that I believed were prejudicial to my interest, and I relied on this provision that each creditor is entitled to notice each court proceedings or a decision. And I hadn't received notice, and Untitled, in fact, was a director on that, not the business rescue practitioners, and the director acquiesced. The director accepted that it was bad. So you're entitled to vote. Creditors have the vote, and we'll get to that because you'll see here participation. So I dealt with the provisions dealing with creditors being given notice. The same applies here to security holders, so shareholders. Participation by holders of securities. So you'll see that security holders are also entitled to notice of decisions. First meeting of employees. Have a look at this. 10 business days after being appointed to the BRP, let's meet with the employees. And this is where you'd want a BRP with EQ, because this meeting is vital. Up till this point, invariably the employees are distrustful. They believe that particularly the blue-collar workers are so distrustful. They believe that the business rescue process is designed to come up with a retrenchment, or they'll lose jobs or something of the sort. What the business rescue practitioner does is he or she needs to explain that the business rescue process is designed to save their jobs, and that the last thing that the business rescue practitioner wants is that they lose their jobs. So the BRP meets with the employees, and it's this juncture that the employees are asked to contribute, to consult, and to provide suggestions insofar as the business plan is concerned. I was involved in a matter, in fact, with Chris Sinclair, who's on the panel of Agility. He was the business rescue practitioner and involved a restaurant in Camps Bay. And the first thing that Chris did was meet with the employees, tell the employees that they are, the idea is to save their jobs. Then Chris immediately met with the landlord. The landlord recognized that there'd be a problem if it did not reduce its rental. It analyzed the cash flows, worked with Chris on the cash flows, agreed to a rental remission for the duration of the lease, and the company was brought out of business rescue, and all the jobs were saved. And that's the idea. So here we go. That's the first meeting of the employees' representatives. Functions, duties, memberships of the committees of affected persons. You can form a committee. The employees can form a committee, which obviously with larger companies is you'd encourage. Proposal of the business rescue plan. I will just quickly skim over this because I will be handing over to Engaged. I'm not sure who in Engaged will be taking over, but Ian or Peter, over to you.
Thank you, Maurice. Let's do it this way. I will talk a little bit, and Peter will jump in as he sees fit. Thank you very much for the introduction earlier. One of the things that's come across very prominently in what Maurice has said is the importance of choosing the correct business rescue practitioner. And I just, this cannot be emphasized enough. It goes without saying, and everybody in the audience probably would have heard about business rescue and probably would have heard some bad business rescue stories. So it is so critical to choose the right business rescue practitioner. You want a business rescue practitioner who will work with the board. And the business rescue practitioner is so much more, the qualification required is so much more than just a chartered accountant or an attorney. As Maurice pointed out, to the EQ side of things, you're dealing with people, you're dealing with livelihoods, you're dealing with businesses that are in severe distress, you're dealing with people's futures at the end of the day.
Yeah, just to interject there, Ian, if you actually think about it, one of the risks of putting your company into business rescue is the appointment of a business rescue practitioner who does not perform his or her functions as required. So it's actually a risk, and it's a risk that has to be factored into the decision as to whether to put a company into business rescue. So yeah,
absolutely. You know, a lot of advocates you speak to, and I'm sure Advocate Don Mahan, who's on this, who's part of the panel, will agree that the success of a business rescue is 99%. The success or the failure of it is 99% dependent on the choice of the business rescue practitioner.
Yeah.
Okay, so all the business rescue practitioners within the COBRA ecosystem, within the COBRA collaboration, have impeccable track records and credentials. So you can rest assured that if the company does end up going into business rescue, it will be a consultative process with yourselves before we put it into rescue, and that your company is literally in the best hands.
Well, the idea is for there to be no rescues, and you know that's the first port of call, is to avoid a rescue by just getting the debtor and creditor to understand that it's in their interest to rather remain in the ecosystem and deal with one another with the professional mediators.
Absolutely, absolutely. Look, the need for a business rescue might come about, you know, further down the line. As Maurice pointed out, nobody knows what's going to happen. How long is there going to be a vaccine? How long will the lockdown actually end up being? There could be, at the end of it all, there could be a lot of confusion as to, you know, there could be creditors who can afford, you know, to give relief to their debtors, but you know, they could. We don't know what's going to happen at the end of the day. So business rescue might be required in order to protect companies from creditors somewhere down the line. So let's just talk about what goes into a business rescue plan. Business rescue plan is basically it's like a business plan. It includes financial projections. Agility, who's part of our panel, is expert on financial projections, as our IQ group, being one of their skills. Yeah, the business rescue plan includes a breakdown of the assets, a breakdown of the asset classes, breakdown of the creditors, breakdown of the creditor classes. Very importantly, it includes a comparison of what the company would achieve in a liquidation scenario. Creditors would be ultimately paid in a liquidation scenario versus what the business rescue plan envisages. Now, this is very important because a business rescue plan is supposed to get a company to return to a solvent going concern. If that is not possible, then it needs to give creditors a better return than they would get in a liquidation. So most of the time, almost all of the time, if we can't return a company to a solvent going concern, then creditors do end up getting a substantially better return than in liquidation. For the reasons that Maurice pointed out earlier, in liquidation you have fire sale of assets, and often the assets get sold for a very discounted value. In business rescue, we've got a little bit more time and a few more mechanisms with which to sell assets. Second thing is that liquidation fees tend to be quite high, and we tend to keep our fees well below the liquidation level.
This was just on that. So the distinction between liquidators' fees and business rescue fees are liquidators take either 10%, 6%, or 3%, depending on the asset class, whereas business rescue practitioners work on hourly rate. Through liquidations, you can ask the master of the High Court to tax it down if, for instance, there's just one asset and it was sold and the asset was worth 200 million. Well, the liquidator needs to discount it. But importantly is there's a chance that it won't be discounted. So have a regard to the value of the assets when it comes to a consideration on liquidation.
Thank you, Maurice. And it must just be spelled out that our intention is always to try and return a company to a solvent going concern, especially within this COBRA ecosystem. You know, we've come across in our track, you know, in our history, we've come across companies where the hole is just too big. You know, there's 200 million rands worth of creditors and 50 million rands worth of assets. That company realistically cannot be saved. You know, it's just too late. In that case, we give creditors a better return than in liquidation. It's essentially a wind down under business rescue as opposed to a liquidation.
Yeah, there's something else that to mention, and Adam sent me a note saying that there's also the CIPC practice note that they'll not invoke its powers with regard to insolvent businesses during the period the Declaration of National Disaster. Now, I know CIPC has effectively closed down because as attorneys, we provide an essential service and we need certain approvals, and it was virtually impossible to get those yesterday. But there again, it's another, by way of regulation, they've introduced something else to assist businesses which complement the business rescue procedure and obviously will be of massive assistance. This doesn't, however, avoid the possibility or potential of a creditor launching an urgent High Court application if the urgency justifies it for a liquidation.
Thank you, Maurice.
Sorry, and can I butt in there? The important thing, of course, is Section 22 of the Companies Act, which is the reckless trading provisions in the Companies Act. And what CIPC has said that they'll not take any action under Section 22. So, Maurice, you're 100% correct. Liquidation proceedings can continue, but it comes back to the reason that we're sitting here through COBRA is to try and avoid business rescue unless essential. So that also would, even if CIPC hadn't conceded on Section 22, it does allow, as you said earlier, Maurice, the board to state that they've entered this program and therefore are not trading recklessly.
So the audience understands why that was necessary is in terms of Section 4 of the Companies Act, the liquidity requirements that have to be maintained. Now, through this, the directors they're going to be massive liquidity issues. And normally in those circumstances, the directors need to take action. They're going to take certain steps to protect creditors. Well, they can't act contrary to the interests of creditors. And that generally, if they keep the business going, and that results in prejudice to creditors, then it can be held to be reckless and they can be held to be personally liable. And that's now what's been suspended. And again, it's very, very important because the duties of directors now are not to liquidate the company in the interests of creditors, but rather, I think they're recognizing that these companies need to be kept alive and that it won't be reckless to conduct oneself or to conduct the company contrary to the provisions relating to liquidity.
Maurice, if I can just throw something out there, and maybe you and Don can also comment, but as to the urgent matters that they're going to hear, I mean, so far they haven't clarified in complete detail, but they talk about best interests of the child, abuse cases, and that sort of thing. And then you also contrast that with that declaration, which is to say, or the regulation, which is to say that legal practitioners can actually get penalized for bringing objectively non-urgent cases to court. Now, in a state of a national disaster, in a state of national lockdown, you might find that a lot of judges are actually saying everybody's in this financial position, everybody's suffering financially. This liquidation isn't actually urgent. I've got abuse cases to hear and that sort of thing. So we yet to work out what's actually meant.
I think there certainly are cases where there's urgency and would justify liquidation. For instance, if there's a dissipation of assets that's taking place and somebody's being opportunistic to dissipate the assets, and employees will suffer as a result of the dissipation. I'm taking our court will hear it on the basis.
Or if it's an essential service, the business is providing an essential service, and that business is now going to go belly up as a result of not getting paid, or whatever the case may be.
Also, Maurice, you'll know that 99% of the urgent liquidations that take place in order to protect the creditor's security. Yeah. So there's a timing issue involved, and they say openly, generally in their papers, that the reason why this is urgent is because there's a competing right for the security, and I want a liquidation so that my right trumps anyone else's right. And that's generally accepted as a decent ground for urgency.
Yeah, I'm wondering, there's other grounds for urgency would be the perfection of a general material bond prior to business rescue or prior to liquidation. So those urgents, it'll be interesting because you can't put the companies into business rescue or liquidation, that urgency goes.
Yeah.
Would you agree?
Well, why do you say they can't put it under business rescue?
They still can later. No, they can put it, CIPC, well, they can resolve, and the consequences of the resolution can happen, but CIPC are closed for business.
Are they not accepting filings online? They have an online filing system.
That's my understanding. Does anybody know? Has anybody looked into it, Dean?
Looked into it. The server was down and they weren't accepting anything yesterday. I'm not sure if it's come up online since then.
Was it just a technical issue? Is the intention that they be open?
We actually don't know. We don't know. The intention seems like it'll be open, especially on that BIS portal one, in placing the, for the essential services certificates. But
Yeah.
So far we haven't had any luck on the filing and them actually accepting any of the electronic stuff.
Can I just jump in there quickly? Our understanding from the information that we've got is that the entire lockdown period will be treated as, sorry, I'm not an attorney, Deus non, which is essentially the same as a public holiday, is it not? However,
so days non is basically the days are not counted for the purposes of a time period. So that's another regulation they put in place. That if there are time periods, those time periods are suspended, obviously because it's impossible to act within those time periods.
I think it might have been Don's opinion, or it might have been somebody else's, but that opinion was that if we send a business rescue the forms or the application to CIPC in advance of an urgent application being launched for liquidation, then it would most likely be considered that the company is in fact in business rescue, and that the application for liquidation might.
Yeah, I'd like to hear from Don on that.
I think that's right. I mean, you'd have to analyze, I think it's Schedule 3 to the Act deals with modes of delivery of documents and things like that. And I think on the CIPC platform, there's a provision that makes it permissible for you to effectively file a document with the CIPC over email.
Yes, we file everything by email.
Right. So documents are deemed to be delivered, at least on a prima facie basis, once they are sent via email. So that would mean that the resolutions and what have you that you need to file with the CIPC have then effectively been filed if you can establish that they have been sent to the right address.
Our reading of the Act says that the moment the email is sent to CIPC with the business rescue forms, then the company is in fact in business rescue.
There's still been a debate that's been going on for some time.
Is there something not in the Electronic Communications Act?
Yeah, I mean, that would play a role for if the Act just referred specifically to delivery, but I think the Companies Act has its own schedules that deal with different modes of delivery in particular ways and say when it will be deemed to have been delivered.
You know what we're going to do? So we put together daily newsletters and stuff. We're going to put together a newsletter on this very topic. So audience can expect that next week as to what our conclusive views are.
Maurice, just on that point, just finally, another lawyer I know did contact the head of the business rescue unit at CIPC, who confirmed over the telephone that email sent exactly as Don's just said. As soon as they send, they will accept that that's the date of rescue. And he said, we are about to send out a notice. And of course, that evening, the notice came out, said non-dies will apply. Yes. So the view that I've got is that whilst it's in the notice from Sub-C, that in practice, they will accept the email submission. And secondly, were somebody to apply for an urgent application during this lockdown period, the view that we got is the courts would certainly frown upon it if somebody had made the efforts to go into business rescue and had complied with Sub-C's rules up to that point.
Sure. And another thing is that if there's any doubt, you can approach the court on an urgent basis for a declarator if the circumstances justify. I've got Adam here. I'm going to direct this, sorry, from Warren, from Engaged, just to deal with the question. I'm not going to deal with it. I'm going to I'll rather hand over to Don on this. And this is the question: if the business is wound down in the business rescue scenario, how are the shareholders' loans treated versus a liquidation scenario?
Well, typically, shareholders' loans are usually subordinated, particularly in circumstances where the company is in financial distress. because where the shareholders are also directors, they may be trading in insolvent circumstances unless they subordinate their loan accounts.
Yeah, often they're required to.
Yeah, that normally means that shareholder loan accounts are concurrent claims and stand at the back of the queue. That may change, of course, once the company is in business rescue, because the loan agreement may be structured on the basis that it's the loan funding from the shareholder would constitute post-commencement finance. And that way, the shareholders can be given some protection. But the pre-business rescue loans would normally stand at the back of the queue.
Just to clarify that, John, that's only if there is a subordination agreement.
Yes.
Well, not necessarily. Even in the absence of a subordination agreement, if the loan is unsecured, for example, then it would normally just be a normal concurrent loan. If it's secured by some sort of pledge or something like that, then the pledge would give you a status as a secured creditor.
And I think important is to conclude on the point, there's the super preferent loans. If a loan is made by a shareholder post-business rescue, then that becomes super preferent. So as I mentioned earlier, always ensure that if you're going to put money in, for instance, for the staff salaries, to do so post-business rescue. We digressed quite a bit. We were going through the process, how it works.
I'll jump in and quickly spell out the process if you like.
Yeah.
Okay,
yeah. So as you've got the resolution, the company's going to business rescue, now what?
Now we send the resolution to CIPC, which we will obviously help the company with. The moment we sent it in, the company is immediately in business rescue. 5 days after sending in the forms to put the company into business rescue, it's then incumbent upon the company to appoint a business rescue practitioner and to advise all the creditors of the fact the company is in business rescue. All creditors and affected persons. Affected persons include shareholders and employees. So that's 5 days after the business rescue has commenced, then a business rescue practitioner is appointed. Within 10 days of the business rescue practitioner being appointed, he then has to hold a meeting, which is known as a Section 147 meeting, during which he advises all creditors of the fact that he believes there is a reasonable prospect of saving the company, returning it to a solvent going concern, or giving creditors a better return than in liquidation. At the same time, he holds a meeting called the Section 148 meeting, which is the meeting with the employees that Marie spoke about earlier. 25 days after being appointed, the business rescue practitioner is required to publish a business rescue plan. I've already briefly spelled out what the business rescue plan entails. Section 150 of the Companies Act has in detail what is required to be in the business rescue plan. We always try and get the business rescue plans out within the 25 days, which is a fairly limited period in which to understand the complexities of the company in their entirety, and also to put together the plan. Hence the reason why, in examples such as SAA, they have requested a few extensions in order to complete the publication of the business rescue plan. It is important to note that should there be massive sort of fundamental changes in the environment or anything that can affect the company, it is a good thing for a business rescue practitioner to in fact request that extension. But in the SAA case, they had the whole lockdown was a fundamental paradigm shift in the outlook for the company. So they actually did the right thing by requesting a 2-month extension. Okay, so the plan is presented. I'm just pointing out that this entire process of presenting or preparing a plan and presenting a plan is really a big negotiation process with creditors. At the end of the day, creditors need to vote on the plan. The plan is required to be passed by a majority of 75% by value of creditors who vote, and a majority of 50% of independent creditors who vote. So independent creditors typically exclude shareholders and directors. Okay, so in the event that, I think it's Section 151 of the Act, 154, if the creditors vote against the plan, then the business rescue plan practitioner has a few alternatives. So he has a few choices. He You can then say to the creditors, how would you like us to amend the plan in order for you to vote in favour of it, in order for you to find it acceptable? And if they still, the creditors still don't want to vote in favour of it, so we've had various instances where creditors have, right from the beginning, for whatever reason, abjectly refused to even consider a business rescue plan. They just wanted to go into liquidation. Then we've got the choice of going to court to have their vote set aside as inappropriate. Okay, and then, yes, the vote takes place 10 days after the business rescue plan is published and presented. Peter, I don't know if there's anything you want to say from your side.
Ian, yeah, just a few things on the independent vote. Just to be clear on that, when you put the plan forward for vote to the creditors, it's as Ian says, those creditors voting, and that's in person or by proxy. So the practitioner and or other creditors can seek the proxy, or the directors of the company can seek proxies of creditors to vote at that meeting. And you need, of those voting, you need 75% to say yes to the plan. Of that 75%, 50% of the total has got to be independent. So in other words, 2/3 of the 75% has got to be independent. And dependence is a shareholder loan, loans from directors' families, loans from directors' companies, intercompany accounts, those are all considered not independent. So it really is truly those creditors that have got no other connection to the company other than the fact that the company owes them money, who have the majority of the vote. The other thing, just because Ian touched on the meeting, first meeting with staff as well, and Maurice did touch on that, just to bear in mind that that's an important meeting if there's a huge labour force, to get the labour force on board with you. The unions will have a say in this. The unions, in terms of the Act, have a say in the plan. But that is also a very important meeting if you are going to go through a reduction in salary, as was talked about earlier, through a consultative process. Then that's a very important time to just let the staff know that their basic rights in terms of their contract of employment aren't affected.
Yeah,
and I think
that pretty much covers the process. Again, if there are any questions, you can post them to the group. I've got a question which I'll deal with now. Alternatively, if you actually want to have a discussion, I can call you up as a panelist, and you can chat to us, or I can give you activate your mic. You don't need to come up as a panelist just to ask the question, so let me know. So Adam actually posted a message. That's Adam, the CEO of IQ, and I've got a request which actually marries up with the message, and I was to explain IQ and Agility's role in all of this. I think it's a very, very important question, because they in essence complete the circle. So we've dealt with Schindler's. We are experts in business rescue. We brief the likes of Don Mahon, there was senior counsel like Josie Brett, who work with us. Then we have engaged the business rescue practitioners. Then comes Agility. Now, Chris Sinclair runs Agility as a tax business advisory service, but he is also a business rescue practitioner. He's a licensed business rescue practitioner. So he comes in, and he is a very, very experienced accountant. You'll see the cash flows will be drafted in no time. Then you have the IQ Business Group. Now, the way business rescue practitioners work is they cannot do everything on their own. So they are entitled to delegate, as they do with attorneys. The IQ Business Group have a team of 700 consultants who are available to assist in this pro bono initiative. And what they've done, and importantly for us, because we don't have the expertise and we don't have the technical abilities to do this, is they've created a war room. And this war room, highly technical, they've got Microsoft involved to create it, because we are helping countless people, business owners, and we've got to track each case, particularly because we've got to marry each case up. We've got to have the debtor and creditors reflected, so we know what relationships to mediate. So that's the war room that they've created, and obviously we're indebted to them for that. But what they also do, and it's their business, is they consult to businesses to improve efficiencies. So they're the obvious partner to have, because if you're going to have the likes of Edcon, who desperately need business rescue to happen, and they desperately need a qualified, a competent business rescue practitioner. But what's also needed is you can't just have Ian running around, or Ian and Chris running around. In those circumstances, we need to plug IQ in. And that's where it's vital. And that's why we've got them. We've got them for the big business. Okay. We're going to be handling SMMEs, but the big business is handled by IQ. Now, IQ are not business rescue practitioners. So they are consultants that will be employed by the business rescue practitioner, or mandated rather, because this is a pro bono initiative. So they will, what they do and their reports and their advice will find its way into a business plan once they've done a full analysis of the business. And then the business rescue practitioners will push that through and present it in tandem with IQ. So I just want to hand over to Adam, because this war room is really exciting, and I think this is really the backbone of the COBRA initiative. I think without it, we wouldn't be able to deal with the volumes that are coming through. So over to you, Adam.
Thanks, Maurice. Just very quickly, because I can see my line is a little bit unstable at the moment. We're making a number of enhancements to the war room next week to provide a consolidation of information. I think it's very clear from the discussion this morning that we're in uncharted territory in terms of all of the various rules, regulations, and what's shifting and moving, and a great deal of uncertainty for businesses at this point. So we'll be consolidating information with regards to the new SME fund, the Oppenheimers and the Ruperts, the Easy Aid Guide to UIF, which obviously is also advancing and moving forward in terms of support. We're working with the Department of Small Business Development. We've got contacts underway with the DTI. And indeed, we're seeking to engage with each of the banks. And this morning, ourselves and Envision Advisory Services had the first of those meetings with one of the big four banks, really looking at the implications of the payment holiday that was announced this week for businesses under turnover of 50 million rand, how they're dealing with non-performing loans, and whether the banks will participate in providing access to post-commencement finance, and their appetite for that in the current situation, and really seeking to get the information share going between COBRA and each of the banks in a two-way process. Because one of the things that's clear is that we've got we've got businesses coming through at the moment that are obviously clients of the banks, and we need to get a two-way process happening in terms of the information from the banks at this point. So watch this space next week. The website iterates and evolves every day, and we'll keep that in a line with the webinars and the information share that's taking place. And I appreciate the process that you've just outlined in terms of our additional involvement in other areas. That's it, Maurice.
Brilliant. I think that concludes today's session. If there's anything that panelists want to mention. Fantastic. So, yeah, sorry.
Quick one from my side. I saw an anonymous question came in, said, are the banks typically the largest creditor and thus dictate the rescue plan, or do they exclude themselves from the process, relying solely on their security? Let me answer that. You know, obviously in our business rescues, we deal a lot with the banks. They are normally the biggest creditor. They certainly do not dictate the process. They very clearly understand the rules of engagement. They're very careful to not try and control the process, but they tend to hold the business rescue practitioners accountable to make sure that the business rescue plans are prepared responsibly, that the business rescue plans are implementable, and that the practitioner also sticks to the rules of engagement. So that's typically the role of the bank. The role of the bank as the largest creditor in most of these matters.
Yeah, I think to mention, just to add to this, okay, so in the Oakdean matter, where it was argued that business rescue was more appropriate. It was the banks that were opposing it, and it was the banks that actually insisted that a liquidation take place and not a business rescue.
Is it not so as well, Maurice, that, you know, again, in these very unique, unprecedented circumstances, I mean, we've got a mandate from our president, from the state, to say, look, be understanding of the fact that everybody's going to suffer difficulties here. So, I mean, I think from a practical and PR perspective, it's going to be unlikely that the banks are going to be wholly unreasonable during this time.
I agree 100%. I mean, the banks are unreasonable in this time. It would be disastrous.
Can I just chip in there? Sorry, the banks are normally reasonable in these negotiations. Once again, it depends on who the business rescue practitioner is, and depends on the company to an extent.
Yeah, I think in fairness to the banks, when it came to Oak Team, there were a lot of grounds to justify liquidation, and that's because there was a hell of a lot of questionable conduct by the directors that the court felt was questionable, that required an investigation. And what the Companies Act has is sections 417, 418 of the old Companies Act, which empower a liquidator to convene secret inquiries and the like. So that's another reason why a court would prefer a liquidation, or would order a liquidation, so that those investigative powers kick in. Okay, so yeah, I think that's Don. Did you want to say something?
No. I'm
okay. Yeah, so this concludes today's session. There's a session every single day. There's the smaller group sessions starting on, well, they've been running this week, and there'll be another one on Monday. Importantly, though, and we've had quite a bit of this, and we found it very, very useful. I had several yesterday. Set up private Zoom meetings with us. You go to the COBRA website, cobra.org.za. You'll find an email address there, or you can email me directly, Crespi@Schindlers, that's CRESPI@Schindlers.co.za. We'll set up the Zoom session. We're also trying to set up a permanent Zoom room, so anybody can just drop in, and there'll be a professional there to provide guidance. So hopefully we'll see you again. Go to our website. There'll be updates all the time, literally on a daily basis. And yeah, feel free. We're here to help. We did yesterday, and we'd like to today. So just let us know. Great. Thank you. Thanks to the panelists. Thanks everyone.